Well, I think we'll get started. I suspect there will be a lot more people coming in, or hopefully. I'm Debbie Diener. I am the moderator for this panel. I'm delighted to be. You may be thinking, okay, Debbie can't count because there looks to be that there should have been 4 panelists instead of 3 plus her. Dr. Bussolini from the Italian Embassy, who was substituting for Dr. Granieri from the Italian Embassy, can't be with us. I got a call. The minister's visit, which made Dr. Granieri have to cancel, also has now gotten Dr. Bussolini's attention. But so I'm sorry you won't be able to hear about Italy, but the good news is we have 3 terrific panelists, and we'll be able to leave even more time for questions at the end. So I'm not going to take very much time because what I really want is for you all to hear from this terrific group of panelists, and then what I will do is have them each speak, and then we'll leave time for questions at the end. So you may be wondering why this kind of topic at this kind of forum and this kind of summit. It's not only timely, but it's important. We assumed, the Planning Committee, that people would know about or have knowledge about the federal laws, HIPAA and HITECH and some of the others, but we realized that there was so much going on, both at the state level, U.S. state level, as well as internationally, that we really wanted to be able to provide at a high level, because there are lots of states and there are 28 countries in the EU, really wanted to be able to provide an overview, just a sampling of what's happening in the states. I mean, for instance, people might know, and probably did, and it was said this morning, that HIPAA, for instance, sets a baseline, and that many states, including the one from which Joan McNabb hails, have done even more. Internationally, it could not be more timely, and Peter Boetsma will be talking about what they're doing in the Netherlands, and we're not going to touch on it, but the impact of the international and EU efforts could not be more apparent given the latest decision by the European highest court on Google Spain, and the right to be forgotten. So we're not going to be discussing that decision, but it's one that just, I think, forecasts how important and how close the relationship between the EU and the United States is, and will be becoming even more so in the future. And obviously we're also going to be talking about some of the policy implications. So what we're going to do is start with Joan McNabb, who comes from California. I'm not going through everyone's bio because they are very, very lengthy and very impressive. California in 2013, just recently, just to give a highlight, passed even more privacy legislation than perhaps the Congress has passed in the last 10 years, 12 years. That may be an understatement. So what I'm going to do is introduce the panelists in the order they will speak. They'll take 10 to 15 minutes. That'll leave time for us to have questions and for a really interesting, again, high-level discussion. So the order we'll go in will be Joan McNabb, who is the Director of Privacy Education and Policy, California Department of Justice, Office of the Attorney General. Then it will be Dr. Peter Boetsma. Dr. Boetsma is the Counselor for Health, Welfare and Sports in the Ministry of Health, Welfare and Sports at the Royal Netherlands Embassy. And then Gautam Hans, who is the Plesser Fellow at the Center for Democracy and Technology. So with that, I'm going to ask Joan to kick off our discussion.
Thank you very much, Debbie. Good afternoon. Happy to be here. Been a very interesting conference so far. Just to give you a little background, before I joined the brand new Privacy Enforcement and Protection Unit in the California Attorney General's office in July of 2012, for a dozen years before that, I headed a small office in state government called the California Office of Privacy Protection, which was basically an education and advocacy organization. And when that office ceased to exist, happily our Attorney General, who did very well in the election yesterday, created a privacy unit that is like Privacy 3.0, or the Privacy Office on steroids, because in addition to the advocation and advocacy function, it adds enforcement, actual enforcement of privacy laws, which is critical because most of the privacy statutes in California, we have a constitutional right as well, but most of the statutes rely on public prosecutors. Only a couple of them have private rights of action. Almost all of them rely on public prosecutors. So having, there are 5 deputy attorneys general in the privacy unit who are hard at work enforcing. I'm in the part of the office that is the education policy side, and health information privacy, the privacy of health information is one of our top priorities. We've also done a lot of work on mobile because that's where so much of our information is and is going and is moving around. I want to talk to you a little bit about the work we've been doing on health information privacy. The California has its own pre-HIPAA health privacy law called the CMIA, the Confidentiality of Medical Information Act, in the Civil Code that I'm going to tell you a little more about later. But so we have a law that was in place before HIPAA came about, and then in several places provides greater protections than HIPAA, and therefore it is not preempted by HIPAA. There were a couple of places where it was preempted because it was in conflict, but there are also places where it's just confused, but some of the stronger protections are still in place. And I'll tell you a little more about that in a minute. A major endeavor on our part on health privacy in the past 2 years has been in addressing medical identity theft. So by that I mean the unauthorized, the fraudulent use of somebody's identifying information in a medical context. In particular, we have focused on the impact of medical identity theft on medical records. So there are financial impacts of medical identity theft that can be forms of insurance fraud, or it can hit consumers themselves who get billed for things that they aren't responsible for. And we have laws and processes for addressing those and ways of detecting that aspect of identity theft in a medical context. But the impact on medical records is much harder to deal with and also can be much more costly in oh so many ways. Having inaccurate information in one's medical record, can be life-threatening. So that's been called, since Pam Dixon at World Privacy Forum and Bob Gelman, who keeps being mentioned here, first wrote about it in 2006, it's been called the privacy crime that can kill you. So the reason that we decided to look at that issue is the happy conjunction of growing awareness of that crime and the move to electronic records, which offers opportunities to bring some of the learnings from other industries like financial services in how to detect and respond to fraudulent electronic transactions. We're not used to doing that in healthcare. Banks are used to doing that. Were and continue to be concerned that in the move to electronic records and health information exchange, there has not been attention in the standards to being able to address medical records, medical identity theft, but we are encouraging it. So we pulled together an advisory group of people. This was a year or 2 years ago. We pulled together an advisory group of people that included some privacy and security experts from outside of healthcare. We had 3 providers, 2 of whom were now in health informatics, some health policymakers at the state level, several consumer privacy advocates, and talked with them about, all right, what could we do to sort of push awareness and make recommendations. And we ultimately produced a document that is a recommended practices guide for the healthcare industry on detecting, preventing, detecting, and responding to medical identity theft. We made very specific recommendations, including things like trying to bring some of the rights that consumers have in regard to financial identity theft into the medical identity theft world. And all the time that I'm saying medical identity theft, I'm talking about records, not the financial piece. In the financial world, if you suspect that you are a victim of identity theft, you place a fraud alert in your credit file, and you get a free copy because of that, a free copy of your credit report so that you can check for inappropriate information. Not the same in the medical world. In fact, if you indicate to a provider that you suspect you may be a victim of medical identity theft, you may run into a roadblock in being able to exercise your right to have a copy, not free, just a copy of your medical records, because they believe they can't do it for some reason, which is not the case. They are not prevented by HIPAA from giving you a copy of your medical record because you suspect identity theft. We are recommending that a copy be provided free when someone suspects medical identity theft, that it be provided, that a copy of the records that are relevant to the suspected facts about the medical identity theft. So not necessarily every x-ray, let's say. We recommend that providers and payers both use technological methods to detect anomalous transactions, flag suspect records, have in place a full plan for how to address and respond to reports of potential fraudulent information. All of our recommendations are directed at identity theft, but they are really as applicable to any kind of errors in medical records, which can have the same very harmful impact. In our recommendations to health policymakers, we included making an identity theft response plan be a certification requirement, or at least a best practice requirement for health information organizations and exchanges and ACOs. We also produced a companion fact sheet for consumers on possible signs of, we call it first aid for medical identity theft, possible signs and what to do, which is one of the tricky things, what to do if you see a sign. So for example, a notice of a data breach from health information. If the Social Security number is included, there's the whole financial steps that you would take. If a health insurance or health plan number is included, we recommend contacting your insurer or the plan, ask them to note the breach in their records and to flag your account number, however they can do that, and watch your EOBs for possible anomalies. We also, another sign of possible medical identity theft that we mention is an unknown item shows up in an EOB. So call the insurer, ask about it, ask for details. Depending on what you hear, ask for a copy of the records related to that item, contact the source of that item, ask them for details, ask them for records. If you review it all and think you have found an error that could be fraud, get a fuller set of your records and ask to have it corrected. And we provided sample letters for each of those requests to the various parties to help people take appropriate action, not necessarily without over-promising to them that they're going to get great responses, but by giving them some good sample letters, we think we can help them push against the system that often enough isn't real helpful in those situations. So that's one of the things that we've done. We also have made medical issues a priority in our enforcement actions. One of our enforcement actions involving a medical concern was against Kaiser, and we came to a settlement with them, and it was about a breach, and it was the nature of the breach was it was employee records actually that were found on a thumb drive for sale in a thrift shop. Don't exactly know the story of how it got there. Right. And it was recovered, and Kaiser took a couple of months to determine just whose information it was and what it was, and then after a few months, they notified employees. And so our complaint was about on the basis of our data breach law, which says you have to notify in the most expedient time possible without unreasonable delay. This included Social Security numbers. So this is the kind of information where you are at risk when it's out there. There's something you can do to protect yourself. Timely notification is critical. And in the settlement, what they agreed to do was, in future, when the facts indicate, as they did in this case, to notify on a rolling basis. So 1,000 people, we know for sure these people were included, and we know what information it was. We'll notify them now, and then the next 1,000. And that doesn't work that isn't appropriate necessarily in every breach, but there are breaches where that is appropriate. You don't have to wait till the last I is dotted and T crossed before you let people know. So that's all I'm going to say right now.
Thank you. You can see why, and I can say this since I'm not in the government anymore, and I'm allowed to be even more opinionated than ever. You can see why we wanted to have Joan in particular and California highlighted, because we heard this morning about so many issues, misunderstandings about what HIPAA can do, questions about what can patients do. You know, I heard, and I've heard this at other conferences, I don't think it's overstating, this sense of we know that patients want to have control, and we know that the personal health information needs to be protected. You know, what can be done? And so one of the reasons, again, for having this panel is to be able to give all of us a sense of there are places, there are states within the United States that are doing very effective improvements in this area. Not everyone can perhaps emulate a California, but it gives a great sense, and Joan's done a lovely job of giving us an overview. I'm going to come back and ask her a question. I'll take a moderator's prerogative when we're done with the speakers and ask her a question that'll help get us into another area that we actually heard about this morning. And we did not set this up, but Joan talking about the electronic health records, I want to turn to Dr. Peter Boetsma, because a lot of what's going on in the Netherlands, while we may think, okay, it's European-centric or particular to the Netherlands, very informative. I'm kind of teeing up, I don't mean to steal your thunder, but really in terms of what can be done from a non-governmental standpoint and having to do with patients' rights and electronic health records. So with that, I'd like to turn it over to Peter.
Thank you, Debbie. Yeah, actually, it's a story about government and then finally ending up outside of the government. What I would like to tell you a little bit about is the struggle in the Netherlands with health privacy.
Excuse me 1 second. Can everybody hear? I don't know how to do the mics.
They're
Are they on?
Yeah.
Okay, good.
As I said, the struggle in the Netherlands with, let's say, the exchange of medical data, health privacy issues, and parties involved. Actually, about 14 years ago, our government tried to set up a system in which we could exchange health or medical information. And that took quite a while. In the meantime, while the system was developed, also the legal background was developed and submitted to our organization, which have to check the laws and what have you. In the end, in 2011, the law on the exchange of medical data was in Parliament. Our House of Representatives voted in favor of this law, but in the end it died in the Senate. And that was quite a big blow for our minister, because there had been a long time working on to get this law into being. The issue was not that the infrastructure was not in place, because largely that was in place, but it was mainly the concerns about privacy. For information is that in the Netherlands, about 98% of all physicians, they work with an electronic medical record. So it's merely a matter of linking those together and then to exchange health information. But after 2011, when this law was voted down in the Senate, our minister said, I don't want to do anything anymore. But there were quite a few parties who saw the interest of this law and the system and decided to group together, which was, for example, the National Association of General Practitioners, the National Association of Pharmacists, of hospitals, specialists, and also the patients' organizations. They joined together in an organization which they established as a kind of a foundation, and they wanted to continue this effort to set up an exchange system for medical information. The initial points of departure for this system would be that it should be self-financed without a government, that there would be individual permissions from patients necessary to exchange the information, and that would be a small-scale pilot, like of regional, more like approach. And originally it was an opt-out system. So when this system was established, we had about 8 million unique IDs in the system. The Netherlands has 16 million inhabitants, so about half the population. But then when these points of departure were formulated, it was decided to go for an opt-in system. So from one moment to the other, we were back to 800,000 unique IDs into this system. And then the organizations, they really stepped up to the plate to really start asking patients whether they would give permission. And there were several ways in which they could give permission to exchange their health information. So that could be in a discussion between the physician when the patient visited the permission, but also via a website which would literally translate like igivepermission.com, and there you could log in with your digital ID. For this story, it's important to realize that in the Netherlands we have a national ID. It is a number of 12 figures, but you can also request a digital national ID, and via this digital national ID you could log in on this site and to give to have a note that you give permission for exchange of data. The permission you give to the generic practitioner and to your pharmacist. In the Netherlands, every citizen belongs to one general practitioner. So if you want to change, if you move to another city, then you go for another practice of a general practitioner, and there you submit your request to be entered in that practice, and in that way every citizen in the Netherlands has a general practitioner. So the general practitioner is really the keeper of your health information. So what kind of information is exchanged? In the first place, it's called the professional summary. And the professional summary is something which the National Association of General Practitioners defined, in which, let's say, the most important health information of a particular patient is included. And the second, it also contains information on what medicines you're taking. And in the first place, it contains information about the last 4 or 5 visits you have with your physician, possibly allergies or let's say incompatible drugs which you shouldn't take, or any other information. So that is in this data file which may be exchanged. The other thing you should know is that in the Netherlands, general practitioners in principle are obliged to provide 24/7 care. So what happens is that during evenings and in weekends, they have set up a system that other physicians take over the care of patients, or that they take it over in a group of general practitioners. If you give permission to have your medical information exchanged when you visit a physician during weekend, when you get suddenly ill, then this treating physician, they can request information from your your regular general practitioner. So he can enter the system. He has a card for that. He puts it in a box. He puts into also a code, and then he's entered into the system, and then he can obtain the information from, let's say, the regular treating physician, where the information is stored. What also happens is that the request is logged into the system. So everybody who requests your information, it makes a note of that particular person. Only registered providers may enter the system, and only registered providers who really treat you may request this information. If you are a patient and you want to know who has requested your information, you can go to a website from this foundation. You enter your digital ID, and then you can check on your own information who requested this information. And since some time, you can also enter in the system that you want to receive an email when somebody requests your information. So, for example, when you go to a physician during the weekend, then you go home and then you get an email, for example, from the physician who requests from the pharmacy the information on medicines because he requests this information, and then you know that it's logical that this pharmacist or this general practitioner that he requests the information. If somebody else it would be would request, then you have in the Netherlands, it's called the organization, it's called the Healthcare Inspectorate, and you can submit, let's say, a note to this inspectorate, and they will follow up on that. And if it's really a serious breach of that, in the end, I mean, that's with escalation and whatever, but they can revoke the license of the physician. So there's really some serious punishments possibility. At the moment, as the situation per June 1, about 80% of all physicians are now in this system, about 85% of all pharmacies, 95% of all GP groups, about 30% of the hospitals, and the number of patients now is around almost 4 million, so it's about a quarter of the population in the Netherlands. One other thing I should mention is that the information exchange is really geared towards on a small scale and really for this 24/7 care. So although the small country we are, we even divided it in 40 regions, and so the information is exchanged in this region. So not outside of the region, only for hospitals, because sometimes you have hospitals have specialized care or whatever, so they attract patients from other regions. They are allowed to, let's say, to request information from other regions, but the only thing they can request is medical information about medicines which the patient is using. So that's the situation at the moment. What other things they are now developing is called the signal functionality, which is still in development. It has been piloted, but there's now plans to introduce that. That is, for example, if the physician during the weekend prescribes medicine and makes a diagnosis and a treatment, then there's now developed a system that also that information is introduced into the medical record of the patient. So then the patient, the general practitioner who normally treats the patient, can switch on the system that in case that there's a change to the medical record on another place, that the information is automatically entered into the system. And the other one is about information about allergy, contraindications, and intolerance for certain drugs. All the software companies in the Netherlands are changing their software in such a way that if this information is available, then immediately it's also entered in this medical record. Maybe one last word. I mean, it sounds, let's say that a lot of people agree now on it, but still there's a small group of general practitioners in the Netherlands. They still think that the system is a breach of the confidentiality agreement between the patients and the physician, and they are now going to court and let's say see how this develops. The general expectation is that it will not really change this. And another thing I should mention is that there's still quite a bit of concern about the Patriot Act, because the exchange system as it is operated by CSC. There's an American company, and in theory the American government could, on basis of the Patriot Act, request from CSC information about what they have in the systems. Now, the thing is that in the exchange system there are no medical data stored, because the data are on the computers and systems of the physicians, but the logging data, so who requested where, those are in the system. So that is still what a bit of a concern is. And I think that's what I want to tell.
Thank you. Yeah, the Netherlands may be a small country, but they are obviously doing a lot of very assertive and aggressive way actions in terms of patients' health and patients being able to opt in, and just the idea that you have 24/7 care. That's a lovely thought. I remember when doctors used to make house visits, but that's dating myself and aging myself. But also the idea that you actually, under the way it's currently operating, and again, no one knows what will happen if that lawsuit is successful, but the idea that patients can actually know who's looked at his or her data and gets an email saying this is what was accessed. I mean, let alone that it's opt-in, which is, as a privacy person, one of the core fair information practice principles that we all want to be able to be asked. That we heard a lot about this morning. Ask me for my, give me the chance, give me my choice. In the Netherlands, they've come up with an approach that is really, I think, very patient-centric. It addresses their needs, and it especially addresses the needs of, I will know as a patient, and I don't mean to overstate this, but I will be able to know who's asked for my information, what they've asked for, and if it's somebody who wasn't authorized, there's an enforcement mechanism. And that's what I found in talking with Peter was so striking, all those aspects, but the fact that there was an enforcement component that citizens could actually use. So now I'm going to turn to Gautam and ask him to do not something that I hope is totally unfair, but having heard what one of our more cutting-edge states in the U.S. is doing, California, and what Netherlands is doing, and just talk a little bit, as we've talked about, what are some of the implications and promises for the United States? What do you see as some of the issues that still exist? Peter at the end mentioned the Patriot Act, again, the globalization of these issues, the fact that companies can be based in the United States but handling data someplace else. It's a whole host of policy questions that have been answered, need to be answered, and if you would just like to take a stab at some of those, I'd appreciate it.
Absolutely. First, I want to thank Georgetown and Patient Privacy Rights for having me and having this panel. I think the conference has been really interesting so far, and thanks to Debbie as well for inviting me. I will try to be, in answering Debbie's question, not reiterate some of the points that have been made earlier and on earlier panels, just as I think many of these issues are familiar, but do bear repeating. CDT, where I work as a nonprofit research and advocacy organization, and we have historic strengths in privacy, and specifically health privacy. My former colleague, Devin McGraw, who spoke earlier today, formerly head of their health privacy project. Now that she's with Manat Phelps and Phillips, part of my work is working on these issues, which I think, as we've all learned, are extremely important, very timely, and concerning in some ways. One of the big questions that we try to think about in a sort of globalized internet and with global apps, devices, services, even providers internationally that have data stored here in the US and vice versa in some instances, the question of transnational compliance and interactions between and among different regulatory regimes, I think, are now more than ever complicated and pressing and deserve our attention. Joan mentioned that in California, HIPAA has preempted some of the provisions, but not all, and that in many instances it's a ceiling and not a floor. But what does that mean for a provider who, may be very small, based in the U.S. and trying to deal with 50 different states, their regimes, the federal regime, and increasingly international? What this means, I think, is that providers who are seeking to collect and use and retain health data need to at least be aware that these are complicated questions. Not everyone can afford, an expensive law firm that can do all the work for you of determining what the different jurisdictions require in terms of compliance, notification, security, retention. But I think not only from a patient-centered point of view is it important to be aware of these different regulatory regimes, it's also really important from, an enforcement point of view. I think the last thing that anyone wants is California Department of Justice or or California Attorney General rather, or any other jurisdiction coming after you for violating a health privacy statute or any other privacy statute that may apply. Now, I don't think that developers and providers should be concerned about this only from a regulatory point of view. I think there's, I wouldn't say moral, but I think that there is a very strong consumer-centric aspect to this as well. And that is that I think, in the context of health, which is so central to our lives, and I think very sensitive for many people with specific conditions, and something that we think about quite frequently these days, you, as a provider, really want to be aware that consumer trust and patient trust is of paramount importance. I think there are very few other sectors that of the economy that individuals feel so viscerally, no pun intended, about. And I think that's because health data is so sensitive and central to our lives and something we deal with on a daily basis throughout our lives. And what does that mean? I think what that means is that I am frequently speaking with reporters and advocates and people who have questions about how do I make sure that my health data is being protected. Unfortunately, there are not easy answers to that question, but what I do counsel people and when I do speak with reporters, what I emphasize is first that to use providers that are cognizant of the regulatory requirements and the policy implications of what they're doing. Try to figure out to what extent the provider is sharing data, collecting data, how they're securing it, who they're partnering with, and make an informed choice to the extent possible. Now, I fully admit that the current regime doesn't make that easy in some instances, and I think that we clearly have a long way to go in making that information clear and understandable to the average individual. But I do think that there is a place for the individual to play a role. I think also being deliberate about what data you collect, what data you provide to an entity is really important. So we've heard a lot today about HIPAA and who it covers and who it doesn't. And I think in the non-healthcare provider context, whether it's with an app or with a wearable device, there may be ways in which individuals can make more informed choices about the data that they provide and what services they patronize. I think the other reason that emphasizing consumer empowerment on this in this area is really important is not only because I think providers should really be thinking and putting their consumers first for a variety of reasons, but also because I worry that sometimes we can be a little bit alarmist about these debates. Not that these problems are not serious, but we don't. One thing I am very hopeful for is that individuals who hear these policy discussions don't run away and freak out and have nightmares about where their health data is going. Now, that's not to say that everything is great. It's not. But I do think that we should be trying to include individuals in the process and not making it seem hopeless. I think that there are real concerns that people need to be cognizant of, but I also think one of the ways to address that is to try to empower individuals to make informed decisions to the extent possible. And when it's not possible, then we really need to have some sort of regulatory or self-regulatory, if possible, but not always, pressure in order to ensure that individuals are being placed first and that their health data is being protected and not subject to misuse or to unauthorized access.
Thank you. One of the reasons we definitely wanted Gotham and the Center for Democracy and Technology, because it's a part of a theme, which is what's happening at a state level, what a state is able to do in the Netherlands, what's being done, but also what was might have started as a government initiative, but then obviously was taken over by the private sector. One of the terrific roles, and I can say this for you, that Center for Democracy and Technology plays in the United States, and I think this is going to be even more important as we go forward, is if the Congress doesn't act, we will be looking more towards policymakers working at the state level as well as internationally to help the United States and other states that aren't as far along as California really make those decisions and how to move ahead and really what priorities, keeping the consumer, keeping the patient at the center of it. So I want to leave time for questions, but I want to, because of all the discussion this morning about mobile apps, I'd like to ask Joan. There seem to be some, and could be my take on it, there seem to be a number of questions that raised concerns about what's going on, what medical information is on mobile apps, how can it be protected, how can citizens know what they should and shouldn't be downloading. And I want to ask Joan, do you think that there's an approach that's being used in California or elsewhere that you would be happy to talk about?
Yeah, we got a law for that.
Yeah.
The Confidentiality of Medical Information Act that I mentioned predates HIPAA. And one of the I'll do that after. In 2008, it was amended to bring into its sway PHRs, personal health records. The way that they are defined is as it made the a business that is organized for the purpose of maintaining medical information and making it available to individuals or to providers for the purposes of managing the health care. And the intent there was to bring in PHRs that were hosted outside of HIPAA, so hosted by somebody other than a provider, let's say. After a few years, it came to be seen as really kind of missing a big chunk, because it only applied to businesses that were organized for the purpose of doing that. So businesses that might have a PHR but do other things, and that isn't, their purpose wasn't to have a PHR, they were not covered by it. And with the rise of the huge increase in mobile apps, and then in mobile apps that are collecting health information that in some cases might be considered a PHR, but would still probably not be provided by somebody who was a company that was organized for the purpose. So now the law was amended again and just took effect this January to clarify that any business that offers software, hardware, an app that is collecting personally identified health information for use by, or actually I call it individually identified medical information as defined in the CMIA, for that same purpose, for an individual to manage his or her health care and or to share with a provider. That type of business that has that software or whatever is considered a provider for purposes of the CMIA. So is considered to be a healthcare provider and therefore subject to the CMIA. There's an interesting so that has some huge implications potentially, and one of the little challenges in trying to figure out exactly what it means is the definition of medical information in CMIA is that it's information that is either collected by a provider or derived from information from a provider. But it's possible to do a kind of loopy reading of this new statute so that because the entity is a provider, therefore the information that it's collecting is medical information because it's collected by a provider. So it may have a bigger grab than it might have seemed at first. So what difference does it make if these entities are subject to the CMIA? Well, one of the ways in which the CMIA is more protective than HIPAA is it regulates and limits disclosures by providers who are defined a little more broadly, even in the other part of the law, to include pharmaceutical companies, for example. It limits their disclosures to basically treatment payment or a slightly smaller subset of operations. And it also imposes disclosure limits on recipients of individually identified medical information. So recipients may not further disclose except in accordance with a new authorization. The authorization requirements in CMIA are very specific. The individual, they must be written and signed by the individual. They must state what uses and what purposes and who. So it's not like, here it is for whatever you want. It's here now for this, and they can be rescinded. So that's what the law is. If this new provision that expands the definition of PHR providers, if that is understood to be if such an app is understood to be collecting personal health information, if you've seen the diagrams, I don't know if anybody went to, I saw it as a webinar, the event that FTC had on patient, what was it called?
The health workshop from last month.
Yeah,
Yes.
yeah, on patient-generated health data. And Latanya Sweeney, who's now the Chief Technology Officer, I guess, for the FTC, had this diagram from a fitness type app of the slide after slide getting more and more intricate web of where the information going, and then one slide that shows which parts of the diagram were HIPAA-covered entities and the much larger number of strands of the web that were not HIPAA-covered entities. Well, all of those, if that information was collected from a California resident, all of those people in the outer web may be covered by our Confidentiality of Medical Information Act, which could mean authorizations are required all the way out there on the web. Now, this has not been tested yet, but it might be. So, in talking about this with somebody else recently, an attorney in private practice, what should we be advising clients? You better, think about ways to get authorizations. Right. Think about how you can do that, which is challenging given the definition of what an authorization has to be, but it would be a good idea in general. So it's sort of potentially putting a little consent back into the mix. But it's not clear that it will be understood that way at this point.
But it's possible.
But it's possible.
It's possible, which is interesting. I want to see if there are any questions. I have one that I want to ask Peter about, but let me see if there are any questions first from all of you. Okay, up there?
So a question for Joanne and also Peter.
Can you speak up just a little bit?
My name is Bettina Exputer. I'm a former California public health officer and founder CEO of Humetrics, who develops the iBlue button medical labs. And we testified at this FTC meeting, and I'm glad that you illustrate your point with that very graphic illustration of the FTC by sharing the data, which on average those 12 apps which were not named, we are sharing data on average with 76 different subtypes without informing properly the consumer. Right? But the question I have for you, Joanne and Peter, is the idea of data transparency. If you want the consumer to be totally aware and responsive to a potential data breach and report back, what about, and I know that the Netherlands are interested in having the citizen access directly their data. Besides authorizing the exchange of the data, the Netherlands are interested in adopting the Blue Button initiative. And that's a movement you see which started in the US but also expanded.
The veterans.
What if, so I would like you to comment on that, with patient given a right to directly access and centralize information in patient database. And in California, what if the state will, for instance, mandate Medicaid managed care plan, California Medical Management Plan, to provide a Blue Button record for the individual to download their information, review it, and share it as they wish. And one of the options is on a mobile device which can securely store that information downloaded from the source without any third-party interference.
Let me just, for those, and again, everyone may know, the Blue Button initiative in the United States actually started with the Veterans Administration, and it's a way for the veterans to be able to access directly their records, and it had to do with the ability for accuracy, mobility, especially because, as is obvious, but I'll state it, members of the armed services, both current and retired, move around so often between and among bases and locations. So everyone may have known that. I just thought I would level set a little bit.
If I understood your question correctly, is that you would like to know what is going on the initiative with Blue Button in the Netherlands, whether
Or
about
something
pay-
s-
Hmm?
Or something similar.
Well, I was specifically, I presented at HIMSS Europe, and the various programs in the Netherlands asked us and would like to implement Blue Button functionality, so I would like you to comment.
Okay.
Blue Button implementation in the Netherlands, as I know it's happening.
Yeah, I think what I could say about this, let me first say that in the Netherlands we have the Law on Medical Treatment Agreement, which is the literal translation, and on that basis every patient has to have access to his own health information, which is stored at the physician. Presently, in practice, that would work out that you go to your physician and said, I would like to see what health information you are storing, and that he gives you a print from this electronic medical record. But there's now also interest, as you mentioned, and I must honestly say I don't know the details, but it came to me via various ways. In the first place, I just had a delegation from the Ministry of Health here, which wanted to look at e-health in the United States, and particularly also at Blue Button, how it came about, how it is used, what the situation is now. And we spoke with Peter Levin, who is more or less the father of Blue Button. And the plan is that it will now lead to a discussion in the Ministry of Health in the Netherlands to see what we could do in the Netherlands to introduce that as well. And yesterday, actually, at the party at deputy head of mission of the German embassy, I met somebody, and he said that he also recently at a conference met a group of people from let's say some foundations and private sector, also very interested in how to use Blue Button. And the third way which came to me is before I came here, I worked at the Inspectorate for Healthcare in the Netherlands, and the chief e-health person there, which I know quite well, and he approached me and said, how is Blue Button functioning in the United States? And there was also personal interest because he has a certain form of cancer and wants to have access to his information in a much better way, a much easier way. And he convened a group of similar people, but also people who know what they're talking about, and also in positions where they really could change. And they are looking at how to start something like Blue Button. So there is a lot going on, but not really in practice something already fixed. I mean, that's what I can say about it.
Interesting.
And I'm afraid I don't know if our Medi-Cal, as we call Medicaid, program is looking at that. I do know that we have a very concerted effort at the state level in promoting, both for ourselves and outward, electronic health records and health exchange. And I haven't been involved in it for a couple of years, so I'm not sure where they are, but I want to find out.
I know we're at stopping point. We're supposed to stop at 3:50. I just have one quick question that I'd like to ask, because what we've heard are some, I think, tremendous policy issues, what's happening at a very progressive state level in the Netherlands. If you had to say, what would be, because there may be people here who are going to go back to their states or their agencies and go, heard some great stuff going on in California and policy issues we need to say in Netherlands. How would you say, what would you say are the first steps, or what would be the steps that be taken? And I'll start with you, Peter, to my left.
Yeah, it's a bit difficult to say because, I mean, the Netherlands is a small, homogeneous country with only 16 million people, so maybe it could compare to some states here in the United States. What I understand from the people I talk to in the Netherlands is that start of at a small scale, that is very important. Big ideas, I mean, maybe some of you are familiar with what happened at the National Health Service in the UK. I mean, also billions and billions of pounds, and in the end there came nothing of it. So I think small scale is very important. And I think for the US, but that is a very difficult issue, is the identification. Now we have had my colleague from the Netherlands on the biopin, but on the other hand, I mean, the fact that we have now a national identification number in the Netherlands and also a digital one, that makes it possible to have these kind of system implemented. And I know that there's a lot of, let's say, political discussion around that, so I won't go into that.
Third rail.
But I think those are issues which I think will need to be resolved if you want to start something like this.
Thanks, Peter. John?
That's actually a hard question. I think that a state as large as California, just because of our size, we are able to do things because we can sort of push the market because they can't ignore us in ways that smaller states can't. And and I realize that creates problems as well, and that in the interconnected world, that a need for interoperability legally too is really valuable. When I first got engaged in health privacy issues back at the beginning, an administration ago, we were working on a project where we were supposed to be, I can't remember what this thing was called anymore, but it was funded by the ONC. We were supposed to be identifying the legal barriers to electronic health information. And so our first step was we redefined that as privacy protections and how to harmonize privacy protections rather than mow down barriers, how to make it workable across. So I don't think I have advice.
Except
It's
start.
hard.
It's hard.
I will emphasize Joan's point that this is a difficult question. What I would say is, I think this is an area where there's a lot of ways that there can be missteps, and so I think being deliberate, but also moving forward is the first step. I think we found that there are a diverse group of stakeholders in this space that all of whom I think need to at least be consulted, if not necessarily in agreement, in how to move forward from a regulatory point of view. But I would say that while the policy questions may be difficult and daunting, it fundamentally is an individual level concern for all of us. And so thinking about how to keep that in mind as these sort of policy debates and policy proposals are put forth is, I think, of paramount importance.
I actually want to backtrack one bit. I think health information privacy is not as hard as a lot of other privacy issues for a couple of reasons. It is more local. The mega companies involved may be international, but the patients aren't.
Yeah.
It is much more local. It's even more state addressable. It's the infrastructure that is international, interstate. So there's a reason to push against that. And I think there are a lot of opportunities, such as the medical identity theft issues I was discussing earlier, in the move to electronic records. There are privacy concerns raised by them, but that move. But there are also a lot of opportunities in it, and because most of the exchanges in the U.S. are regional, you can actually have a better chance of being able to establish some rules potentially.
And I was going to say, look at shining examples of what has been done in 2 different places, and the takeaway for me, if someone asked me, is strategic incrementals. Start with something that's doable and build out. I've read the various California laws and the amendments and what they are. It's very iterative. They start with a good base and they build on it. So thank you all for being here. I've enjoyed being here today and working with these panelists, and if you would join me in thanking all of them for their time and their expertise. And I think we go back downstairs now, so thank you all.